So now that Julisse is on, so my name is Romy Jurado. I'm an attorney here at Jurado and Farsian. Julisse is also an attorney here at Jurado and Farsian, and together we handle litigation in our firm. The presentation today is meant to answer some common legal issues that we've encountered in the litigation dealing with businesses. And we'll just have a quick presentation, and then what we would like to do is take some questions and address some issues as we go. So Julisse, go ahead and introduce yourself.
Hi, my name is Julisse Jimenez. I'm an attorney with Jurado and Farsian, and I focus mostly on the litigation in the firm. We see a number of litigation cases that come in that range from anything from somebody owing $500 to millions of dollars, and then disputes among business partners. And so we're going to talk about all the different issues that we encounter on a daily basis, how to try to protect yourself against those. So Romy?
Perfect. All right, so I'm going to start by sharing my screen, and then we can start looking at our presentation. All right. So ins and outs of business protection. This is a little outline. We're going to be talking about lease agreements, some interesting things about entities and personal liability, the corporate bail, piercing the corporate bail, and then tips and tricks to strengthen the corporate bail, some employment matters, and lastly, contracts. Lease agreements. Lease agreements are vital for any business. The relationship that you're going to have with your landlord, it's going to be the most important relationship after the one you have with your business partner. Why? Because the landlord can regulate anything and everything that you do when it comes to your business. If your commercial lease doesn't allow you to pass out leaflets to promote an event that you're having in your gym, you cannot do it, even though you're renting the space and you want to be outside and get some clients. You're just not legally allowed. So you want to make sure that you fully review your lease before you enter into it. And if you already entered into it, maybe upon renewal, it's a good time for you to negotiate certain issues of your lease so that you are fully protected. When somebody comes in, a startup, and tells me, Romy, I want to start a business, can you please review my lease? The first thing that I ask this startup or business owner is, have you engaged a realtor, a tenant broker, meaning a realtor that focuses on commercial leasing? Why? Because these realtors that focus on commercial leasing, they're going to know what's market, what the fees are currently in that area per square footage, what that landlord has rented for before, what options you have, whether a landlord is amenable to some free rent or not. So it's very important for you to work, I would say, with a realtor that specializes in commercial leasing, not just any realtor. Also, engage the services of an attorney, not a family lawyer, a divorce attorney, a criminal lawyer, a slip and fall attorney. They are not familiar with commercial lease terms. And as I explained to you, the relationship that you have with your landlord after the relationship with your business partner, it's going to be the most important one for your business. We have seen that a lot right now, especially during COVID. I have clients on one end that are surviving because their landlord is understanding and because their lease allow them to be able not to pay rent due to a pandemic, okay, because they have certain classes that we're going to discuss. And I have tenants on the other end who basically had to shut down. Not only did they lose their business because of Corona, but now they shut down and they're still liable under the lease. The fact that they cannot operate because the government says you have to shut down your store doesn't mean you have the right to stop paying the lease, unless your lease or agreement says something that can protect you. And Julisse and I are going to discuss that in a minute. Some basic terms that you need to be familiar with that would seem very simple but are not are, for example, rent. Rent in a residential type lease, it's basically the amount you pay. It's a basic amount. It's always going to be the same or increase yearly. In a commercial lease, rent can be defined as whatever the landlord wants. It could be a basic rent. It could also be the common area maintenance. It could be any another expense that the landlord decides to add, and they could all call it rent. I have seen leases where the landlord includes the salary he pays his spouse to maintain the property or to market the property, and their trips they take to, I don't know, other countries to promote the commercial place, all of that being called rent, and then the tenant has to pay it. So you want to be really careful. Full service versus triple net lease. These are descriptions of the type of lease that you're going to engage. But don't get tricked by reading something that says full service, but then at the same time, you're responsible to pay taxes, you're responsible to pay insurance. So it's really a triple net lease. What you want to do when you see these titles is understand the body of the document. What does the lease say? What are you really paying? What are you responsible for? And then you can understand what type of lease you have. Premises. In a residential lease, it's very easy to define the premises. You usually have an address and that's where you're renting. In a commercial lease, it may not be as simple because sometimes we do not have an address per store. We have an address for the shopping center, and then each store is called Bay 1, Bay 2, number 1, number 2, and it might not be defined. And that's an issue because you might think you're renting this space that has this beautiful, area in front of where everybody passes, but in reality, you're renting this space all the way in the back, or the landlord tells you that's what you rented. And if you don't have a drawing or something that says this is the space that I'm renting, they may easily move you. Security deposit. Landlords can ask for whatever amount security deposit they want, and you need to be careful when reading the lease. We have issues where the tenant came in, they pay, whatever 1 month security deposit, but then on the second year, the lease says the tenant has to pay 3 months security deposit. And if the tenant doesn't pay those 3 months security deposit, that will be considered rent. And because it's considered rent, now we have an issue because they can sue you for lack of paying the rent and evict you really quickly. You understand? They only have to give you 5 days when they sue you for possession because of not paying rent. And the only defense to paying rent is, yes, Your Honor, I paid it. But in this case, we had somebody that had paid 1 month deposit. Then the second year, the lease said that they had to make a 3 month payment of deposit. They didn't understand, they didn't know, they didn't have the money, so they didn't make it. So now that is considered additional rent, and now the landlord can evict them for not paying rent and serve them with a 5-day notice. All because they didn't understand their lease. The fact that you don't speak English or your English is your second language, it's not an excuse. The courts will say that you are sophisticated people, you're entering into commercial transactions, and if you don't understand what you're doing, you should have hired an attorney that did so they can properly advise you. So it's really important to read the lease. Improvement allowance in base buildings. You could always ask the landlord to give you some improvement allowance. This is some money that where you can use to do the build out of your premises. If you rent an empty shell, an empty space, you may think, oh, this is perfect. I can just put my furniture, I'm ready to go, open up my store. It's not always the case, especially when it's an empty shell. You have to get a lot of different permits. You have to do it however the city wants it. So you want to make sure that you have some type of improvement allowance that the landlord gives you so you can use it for your build up. The worst that can happen is that the landlord says no, but at least you've asked for it, so now you can maybe get it. Use an exclusivity clause. This is really important when it comes to renting a space, especially for those providing products. Services too. For example, we had an issue where our client was a restaurant in the Italian food, right? So they sold Italian food. They rented a space within a commercial plaza. Well, the landlord was also negotiating with another restaurant person to sell. It wasn't Italian food, it was Italian ice. So you would think it's not the same. It really isn't the same, right? One is kind of like dessert, but then my client, it's more like a restaurant. But my client, as part of their desserts, we're also going to sell Italian ice. So what we needed to do was negotiate an exclusivity to where our client was the only restaurant selling Italian food and Italian related desserts. Why? Because otherwise, everybody that would maybe want to try something Italian, they would go to the other vendor and not to our clients. It would take away clients from my client. So those are things to think of when it comes to exclusivity, especially now in the time of technology where everything you find people online. For example, if you're a CPA or accounting services in your building and somebody wants to find a CPA or accounting services around the area, if there's 4 other ones in your building, they're gonna find them and not you. So even though you're in a service industry, exclusivity may also come into play, especially for restaurants. I see it a lot for restaurants. When you focus, for example, on Argentinian food, that you don't want a bakery selling empanadas, for example, because they might take business from you. So you want to think about what's your use, what do you want to get an exclusivity on, and then negotiate with the landlord. The landlord may not allow it, that's okay, but at least you try. Assignment and subletting is another issue to consider, especially in, for example, the beauty industry. The salons, if you think about it, each of those chairs is independently operated by one of the hairstylists that may not be an employee of the salon owner. They may just simply be operating that chair. So in reality, the salon owner is subletting to them. if your lease doesn't correctly reflect those things or has an arbitrary, just, you know, no subletting of any kind, you might run into issues where the landlord would say, I rented to you, not to them, and now you have to, you know, work with the landlord, maybe pay him more money. Same thing with real estate brokerages. You know, the real estate broker rented the space, but each of the realtor that works for them, sometimes they're even their own PA, as I highly advise realtors to do. So their own little company. And now the landlord may say, well, I rented to you, not to them, so you need to pay me more, or you need to do something so that I allow the subletting. These are issues that may come up, and you definitely want to just address them in your lease before you rent. Renewal rights, I always advise clients to negotiate renewal rights. Why? Because you may really like the place, but now your lease expires and you have no option to renew, you're gonna have to move. So you want to negotiate options to renew, and you also want to negotiate caps on those options to renew. Because what if, yes, you're able to renew the place, you're so happy, let me go renew my lease, but now the landlord comes back and says, well, we're going to increase your rent by 30%, by 40%. There's nothing to stop the landlord. And it's so sad when clients come to me and they're like, Romy, I love this place. I made it so beautiful. Look at the pictures of before, look at the pictures after. And now this landlord wants me to be out or pay him 50% more of rent. Romy, this is really unfair. Please, can we go to the court and tell the judge how unfair this is? And you know what the judge's going to say? Too bad, so sad. You didn't bargain for that. You're a sophisticated tenant. You should have foreseen this and negotiated something to protect you. There's nothing that I can do. So we want to make sure that we negotiate renewal rights if you're the tenant with a cap on those renewal costs. You don't want the landlord to be able to increase your rent by 30, 40, 50%. Maybe 3% is acceptable, 5%, even 10%, but not so much. And why not do a whole, you know, long-term lease? Because you don't know what's going to happen. You know, with this thing with COVID taught us exactly that. We don't know if we are going to be happy in that location for 5, 10, 20 years. But what you can do as a tenant is maybe have a 3-year lease and then maybe 4 other options to renew of 3 years each. So now you as a tenant are in the driver's seat. If you like the location, you stay, you renew your lease. If you don't like it, you can simply move out. Alterations. If you think you're going to be modifying the place, you're going to be doing some construction, you can get it approved from the get-go in your lease so that you don't have to chase the landlord around to try to get approval for something. Environmental, ADA, and code compliance, whenever you're renting and you're opening the space out to the public, you're basically inviting people there, and if you're not complying with the ADA, they can come and sue you for it. Yes, they might end up suing the landlord as well, but you as the business owner, you're the one that opened the doors, and they're going to hold you responsible. So you want to make sure you have those inspections in place, and you want to make sure the lease says that the location is compliant, and that if it isn't, the landlord will indemnify you. Rent abatement for interruption in use. Your duty to pay the rent, it's not tied with your right to use the premises, as we saw that right now during COVID. You know, you couldn't use the premises, you were shut down, but guess what? You still had to pay rent. You still have to pay rent unless you had a special clause. And Julisse, can you tell us about that clause that I'm referring to? Oh, you're in mute.
That would be the force majeure clause that you want to have in your commercial lease that basically says any interruption in business or any, you know, interruption due to the government or any laws or regulations that are, you know, that are passed, or because of a hurricane, a fire, or, you know, any other catastrophic event, that you actually can abate your rent for the time that you're unable to operate your business, or that you're, you know, required to be shut down. That's very important right now, and people are finding out that unless you specifically have that in your contract, you cannot waive rent. Although you may be closed and there's nothing else you can do about it because the government won't let you open, you still have a duty to pay rent. So unless your landlord is willing to give you an abatement just because they want to keep you as a tenant, legally, you still have to pay rent. And even worse, you may shut down forever and you still have to pay rent. And they have a right to accelerate the entire rent. And let's say you had 5 more years at $5,000 a month or $10,000 a month, and that is all going to be due at the same time. And most of the time, they're guaranteed by the person who owns the business. So that's going to be a debt against the individual as well. So that's why it's important to have the force majeure clause in your lease.
Absolutely. Thank you. All right, so that was a little primer on commercial leases. Julies, before we go into personal liability, any other thing regarding commercial leases that we may want to talk about, you know, issues, legal issues that we have seen that we might want to discuss?
Right now, something that a lot of people keep asking is, well, I know that there's a ban on evictions right now going on, you know, across the United States, and specifically Miami-Dade County and Broward County. And a lot of people ask, well, does that mean that I don't have to pay rent for my business? Does that mean that they can't evict me? And the answer is no. The ban on eviction is only on residential properties. So they can actually evict you right now if you have a lease and you haven't paid rent, even though we're in COVID-19. So that's a question right now. So if you can work out something with your landlord, for the time being, we're always, you know, available to help. We negotiate a lot of things with your landlord. That's, you know, that's important to address, because yes, you do have to pay rent, and yes, they can evict you. And like what we said before, you can be personally responsible for the rent. The other thing is, sometimes, you know, you wonder, well, what happens is, and we have seen this in cases, what happens if I'm in a shopping center and I have a great business, I have a children's daycare, and on the other side of the shopping center, there's a place that sells liquor, and you know, they have a whole bunch hanging around there all the time. They're drinking outside the space, you know, during the time that the parents are picking up the kids at 6, 7 o'clock at night. And, you know, that's creating a nuisance for me. So you want to make sure that your lease specifically says that any nuisance that is caused in the shopping center that doesn't allow you to operate your business or that hurts your business, it is the responsibility of the landlord to deal with and to pay to remedy the situation. For example, put more you know, security guards, or, you know, whatever they need to do, but that the cost is passed on to the landlord, because otherwise you're going to be stuck with a business that is being interrupted, and you're like, what do I do? Well, you know, unless your lease says something like that, you're going to have to take somebody to court to determine who is responsible for that. The other thing is repairs. A lot of leases are silent as to who makes certain repairs. For example, let's say that the roof is damaged with a hurricane, and then there's leak and there's damage inside the unit. If your lease doesn't say, most of the time, you know, that the landlord is going to be responsible for the roof. But now, what about everything that happened inside your business? You know, if your lease doesn't say, you're going to be responsible for it, and you should have insurance. But if you don't have insurance, you're going to have to pay for that if your lease doesn't say that. So you may want to make sure that, you know, any damage that is related to, let's say, the roof or plumbing, that is, you know, the responsibility of the landlord to take care of, but that damages my business, that is covered by the landlord, and that they either give you a rent abatement or that they repair for you, but that is addressed. And finally, the other thing is the security deposit. The security deposit in commercial leases is guided by the contract. It's not guided by a statute. Therefore, if your security deposit doesn't say that it's going to be returned to you within 30 days after the lease is done, or how is it going to be returned, or what triggers the return, then what happens is the landlord is going to take, and you're going to have to sue them to find out when they should have done it. You know, is it 6 months reasonable? Is 3 months reasonable? You know, what are the events that would allow them to retain the security deposit? Do they have to give you invoices if they're talking about repairs? So you have to be very specific on your lease with regards to that. So Romy, yeah, we can move on to the
corporate bail. Okay, so what I usually tell my clients is, whenever you go into business, it's as if you're standing on I-95 and cars are coming at you. Sooner or later, you might end up getting sued, more sooner rather than later. That is one of the reasons why people incorporate or form LLCs or form, you know, corporation. Why? Because this concept of the corporate bail. Corporate bail is a legal concept that separates the personality of a corporation or LLC from the personalities of its shareholders and protects them from being personally liable from the company's debts and other obligations. So if somebody sues your company, right, like I said, you're standing on I-95, cars are coming at you, there's going to be some type of bail, some type of stop, so that they can only attach the assets of your company, but not your personal assets. Now, why is this important? Because you don't want to expose everything you've saved throughout your life just because you went into business. And in order to avoid that, you want to make sure that you have a proper company form, you followed all the formalities, and that, you know, certain things you're not doing. For example, if you're using the bank account of the company as your personal piggy bank and you're using it to pay everything, you basically expose yourself to liability, because now it's going to be really easy for an attorney to say, guess what, Your Honor, that company's, it's just a sham. They're just using it. It's really them using it as their piggy bank. So there should be no corporate bail. It's basically the same person. The company and the person are the same entity, the same person. So we can sue them personally and make them personally responsible. So that's very important. Do not use your money for your company for your personal use. Now, of course, you can use your company's money to pay your personal stuff if you first take the money out of the company, either as a distribution or a salary. So I'm not saying don't, you know, you can never use the company's money. That's not what I'm saying. I'm saying get the company's money out in a proper manner, whether it's a salary or a draw, distribution, whatever it is, meaning now it's your money, personal money, and now you can use it for whatever you want. But don't use that company's money to pay for your apartment, to pay for your, you know, your hair appointments, your medical doctors, your trips all over the world, unless they are really, you know, dealing with business trips. You want to be careful with this, because you don't want, for mistakes such as that, to not have any type of personal liability. Now, there are certain causes of action, which we're going to deal with Julisse later regarding employment, that even though you have a company, you're still personally liable. For example, if you don't pay your employees overtime, you're still personally liable. If you don't have workers' comp, you're still going to be personally liable. If you engage in some type of criminal fraud, you cannot hide behind your company and say, okay, no, don't touch me. You can't do that. You're still going to be personally liable. So we talked about the piercing the corporate bail. So what are some tips and tricks to strengthen that bail, to make sure you do have this liability protection? Well, first, incorporate. If you're just simply doing business, you know, you just, when they started working, you even file for a DBA, you do not have any type of liability protection because you're basically doing business yourself. So first step is incorporate, whether it's an LLC or a corporation, file the actual documents so that you can have that corporate bail. In Florida, the law changed in 2015. I don't advise clients to form single members LLCs because the law doesn't allow the same liability protection as they would a multi-member LLC. So please, if you're forming an LLC, form at least a multi-member one in Florida. You can give somebody a 1%, that's not going to be a problem, but at least you're going to have liability protection. When it comes to when it comes to liability protection, it's very important also how you sign the contracts. It's not good if you have a company that you formed and you have followed all the formalities, but now you're signing contracts left and right under your personal name for business things. If you're signing contracts under your personal name, you're going to be personally liable under that contract. If you guarantee a contract, so the contract is in the name of your company, but you're personally guaranteeing it, you're still going to be liable under that contract. So you want to make sure that everything that you do is in your capacity, whatever role you're playing under that company. So for example, if I'm signing on behalf of an LLC and I'm the manager, so it'll be Romy Jurado as manager of Kitty Cat LLC. If I'm signing on behalf of a corporation, it would be Romy Jurado as president of Kitty Cat Corp. It's not going to be Romy Jurado by itself because now I'm becoming personally liable. So if you form an LLC or a corp to have the personal liability protection, how you sign contracts can greatly impact whether or not you're going to be protected. Maintain a separate status. We talked about this. Have a separate bank account. Don't commingle funds. You want to make sure that you're always following corporate formalities. If the company is making a big decision, you want to have a written statement. You want to have a corporate resolution authorizing whatever decision the company is making, because unlike you and me, where we make a decision and we act on it, a corporation or an LLC makes decisions in writing where the relevant parties, be it shareholders, members, officers, have voted to approve that decision. So you want to make sure that you have that. It's a very simple document, a corporate resolution, something that states, we on this day decided to take this loan for the benefit of the company, signed by whoever the shareholders are or whoever the officers are. Fulfill state requirements. A lot of times people go, they form their own companies and they forget about it. Remember, just because you form a company in Florida, it's not forever. You have to renew it every year. And if you don't renew the company every year, then you're no longer following formalities. And now your liability, personal liability, is no longer going to be protected. So you want to make sure that you're renewing your company every year. If we form the company for you, then we will take care of it and we will remind you, every so often. Julisse, anything else about personal liability when it comes to companies and so forth?
Yeah, there are several instances which, regardless of whether you're using your company or not, you're going to be personally responsible for. And those are employment matters and also matters related to environmental issues. So for example, if you have employees and you don't pay them minimum wage, you're personally responsible for that. So they can not only sue the company, and you can say, well, the company doesn't have any money to pay the employees, but they can actually go into your personal bank account then and, get you or anybody who has, control of the payment to employees personally responsible for paying them. So that's the case if you don't pay a minimum wage, if you don't pay them overtime, if you interfere, for example, with the Family Medical Leave Act, that they can also personally get you because you're personally interfering with that. So you can have personal liability under the Family Medical Leave Act for those matters. Right now, it's very important that you're familiar with that because the Family Medical Leave Act has been extended to all companies related to COVID-19 related issues such as, somebody being sick, having to stay home to take care of kids, and, or somebody else that is sick with, within the family. So usually the Family Medical Leave Act doesn't apply to smaller corporations, but right now is applying to everybody. It's even, applying to more time and pay time that wouldn't apply before. So you have to be very careful. If somebody, for example, is sick or tells you, I can't work, at the office right now because my children are, only doing online learning and I don't have anybody to take care of them. So you want to make sure you consult with an attorney and you ask specifically, what do I do with this employee? Because, they can be going after you personally in addition to your company. With regards to environmental matters, for example, if you're renting a premise that used to be a dry cleaners or they used to be something like that, they have environmental impact. And you have to make sure that your lease will say that if, any environmental impact is found while you're occupying it, as long as it's not your fault, then you're not going to be responsible and you're going to be indemnified by the landlord. Because what happens is it's not only the owner of the property who's going to be responsible, but also whoever is occupying it. And that goes to personal liability. That actually the federal government will come after you personally for that. The other thing is, for fraud and other issues like that, what we have encountered, for example, has been employers that didn't classify employees correctly. For example, they had them pay him as a W-2, and then they would pay him, let's say, $100 or $200 cash every so often, and they didn't report that to the IRS. Well, guess what? Now you're personally responsible for lying to the IRS on the tax returns because those cash payments should have been reported somehow with a 1099, with a W-2, whatever it is, even if it's reported, incorrectly, as long as it's reported, because if it's not, then it's fraud on the IRS and you're going to have a big problem and then you're going to be personally liable. So, the other thing is what Romy was mentioning with regards to signing personally for the company. You always want to make sure, like she was saying, that you put your, as what capacity you're signing, as a president, vice president, secretary, member, authorized representative, whatever it is, but just making sure that you're not, John Smith signing as John Smith, but you're signing John Smith as a representative for the company. So that's with regards to personal liability.
Perfect. Thank you, Julisse. Okay, so some employment matters, as Julisse previously covered. It's very important how you classify your employees. Just because you're paying them on an hourly basis does not mean, or because you think that you don't have to pay the IRS because they're only here, a couple hours a day, doesn't mean they're independent contractors. If you have control over them and you tell them what hours to work, they're your employees and you need to pay them on payroll and report it to the IRS. Otherwise, you're going to be facing problems with the IRS. It's very important when it comes to your employees, like I usually, let me go back to the previous slide. Your employees can be your biggest assets or they can be your worst liabilities. So you want to make sure that you know who your employees are. So you're supposed to be doing I-9s. This is a document from immigration that you're supposed to make every employee fill out, and then you need to sign and confirm that they have the legal right to work here. If you don't have an I-9 for each one of your employees, you are facing liability to immigration. You can be subject to an inspection, and we're seeing them a lot, especially now during this environment. And not only that, but they can punish you. They can give you fines. It's really not something you want to be facing. So for every employee that you have, they're supposed to fill out an I-9 that will tell you that the person has the legal right to work here in the United States. So make sure that you have an I-9 for each one of your employees. Then you want to make sure they're all on payroll, right? If they're employees of your company, they're not independent contractors. And then you keep accurate records of their working hours, right? So if they're working 8 hours a day, that's great. But if they're working 8.5, now you need to pay them half an hour, time and a half for that extra half hour. So if they make $10 an hour for the first 8 hours, that's fine. But for that extra hour that they work, you need to pay them $15. And if you don't, you're going to face liability not only for the time that you didn't pay them, but a lot of times attorneys will take these cases on contingency to file a lawsuit against you, and now you're responsible for their attorney's fees and costs. And these cases can be brought in federal court, so they're even more expensive. So you want to make sure if you're having employees, if they're working more than the 40 hours a week, that you're paying them overtime. If they don't have to work more than 40 hours a week, then don't have other people work for you, because otherwise it might become a little more expensive. I don't know, you need to look at that in your business, but it's really important. If they're working more than 40 hours, you have to pay them overtime. Even if they're salary, just because they're salary doesn't mean they're automatically exempt. We can analyze a particular situation to tell you, yes, this employee is exempt from paying overtime, this one isn't. So I can tell you for sure attorneys are exempt, no problem, but I cannot tell you that from any other profession. So you want to make sure that you hire us or another employment attorney to analyze whether the employee that you have is exempt, and therefore you don't have to pay them overtime. Otherwise, always think that you're responsible for overtime. One thing that we see with employment matters too, especially when they become liabilities, your employees, is when they compete with you. Right? So you hired an employee, you trained the employee, you taught them everything you knew, you've introduced them to all your customers. Now they leave you and open up shop right in front of your business and take away all your business. Is there something that you can do to stop them? Well, did you have an employment contract? Did your employment contract have some restrictions against competition or against them using your confidential information, such as your vendors and your clients? Did you have an employment agreement protecting against all of that? If you didn't, it's going to be a lot harder for you to sue them, to stop them. We actually just have a case right now where we're working on something similar where there was no contract, and now we're trying to find ways to enforce the protection because it really is killing our client's business. And our client really trained this person and taught them everything the person knew, and now the person took all that knowledge and started competing with our client, even while that person was working for our client, which is really, as a business owner, that really hurts me because I know how much time you invest in your employees, but at the same time, you need to protect yourself. So Julisse, what can employers do to protect themselves against competition from their own employees who they have spent time training and really giving them all of their knowledge and introduce them to all of their contacts, and who may leave their, their place of employment with all the knowledge and contacts? What can an employer do to protect themselves?
Okay, one of the things that you want to do at the beginning or continuing through the employment relationship is have them sign a non-compete agreement. And non-compete agreements have to be very specific. They have to be reasonable within time and scope. What does that mean? So let's say that I have a beauty salon and I have something that I train my employees how to do that is different how other people do it, or maybe how you care for the employee or the pricing or things like that the employee is going to have access to. So what you want to do is you do a non-compete for, let's say, okay, if you leave while you're employed here, and if you leave for 2 years, you cannot go work for this same type of employer within a 2-mile radius. that's probably going to be enforceable because it's a very small area. But if you say maybe a 5 or 10 mile radius, that may be too much for somebody that works in the beauty industry. And it's industry by industry. So a non-compete is important. But let's say, for example, I've had cases where somebody develops a specific technology that they're going to use to export cars. And, you know, and it's web-based or something like that. Well, now the salespeople have access not only to the pricing that they may have to export the cars, but where do they get them from? And they're doing this all over the world. So maybe in that case, the non-compete is going to be a little bit, you know, more extensive. For example, you can't work for 2 years in this capacity of determining pricing or doing the negotiation with the suppliers for, you know, the geographical location of all of South America. And that may be enforceable because the type of knowledge that that person may have is very specific to a very niche, you know, technology and to very niche market. So it all depends on the type of business. The other thing is, and you can do this non-compete, you can do it at the beginning of employment, and then you can do it later on. So let's say that the person gets a new position. At the beginning, you know, this person was just doing, let's say it was a nail technician for your beauty salon, but now that person is the manager. So when they turn into the manager, you can definitely now give them a non-compete that it's, you know, very specific to that position. But let's say that right now your business, nobody has a non-compete and you would like certain employees to have them. Well, having continued employment relationship is also a reason to provide a non-compete. So let's say you want to give it to them and they're like, well, you know, what consideration am I going to get? Well, your consideration is your continuation of employment. You can sign it and continue to be employed, or you cannot sign it and not continue to be employed. So that's a decision that they can make, but it allows you to provide a non-compete at that time. The other thing that that you can do is an agreement that basically they're going to take care of trade secrets. They're not going to, you know, go give out the trade secrets. They're not going to give out your customer list. They can't take them with them, and you know, so you can incorporate that into your agreement. Now, if you don't have an agreement, there's still things that you can do later on if an employee leaves and let's say takes your customer list that specifically says how, you know, you price your products to those specific customers, or, you know, what makes those customers buy, or, you know, how to contact them that is very specific because they're, let's say, high-end customers that, you know, it's very difficult to obtain information from. You can always request an injunction from the court and you can sue them. So even if you have an issue later on, that's something that you can address, but it's better to address it at the beginning with an agreement that specifically says you can't take this, you can't do this, you know, you can't compete with me. So there are different ways to do it, at the beginning, in the middle of the relationship, or at the end.
Okay, perfect. Thank you, Julisse. So that's for employment matters. So lastly, we're going to talk about contracts. So a contract doesn't have to be a fancy, long, you know, a bunch of paper, something that you don't understand that's written in legalese. That, I mean, a contract doesn't have to be that way. A contract should be a paper document that you can read and understand what your obligations and rights are under that paper or document. So if you don't understand the contract, it's not going to help you. So these are my tips and tricks of what a contract should basically have to be able to avoid litigation, or at least, you know, help you during a litigation. So first is the official names of the parties. You want to make sure that you correctly name the parties. Is it the name of the person? Is it their legal name? Have you looked at their ID? You want to make sure if you're naming a corporation or LLC, where is it incorporated at? Because remember, we can have Kitty Cat LLC in Florida and we can have the same company in California. That is why when putting company's name, we always put the name of the company and the state of incorporation or formation. You want to include that in every contract. And if you're naming a person, remember, people can also have the same name. So you can definitely, to be sure, put their legal name. You can also put their driver license. You can put the address where they reside. That way you know who you're talking about. Also, every contract should, at a minimum, say what each party must do to perform the contract. I've seen, 30-page documents where you read and read and read. It's very confusing, but it doesn't tell you who's going to be doing and what. It doesn't really tell you that. And it can be really simple to just address that point, and it's going to save you a lot of headaches. Lastly, okay, so it may say who needs to do what and what the duties are to perform, but when do they need to do it by? If your contract just says, this needs to be done, this needs to be done, this needs to be done, but it doesn't say by when, that contract is really not going to help you. Then time limits on payments. I've seen contracts where they identify what the duties are to do, what needs to be performed. They say when they need to perform it by, but they don't tell you when you need to get paid or make the payment by. If it doesn't tell you that, again, you're going to face a problem, because now all the duties are going to be performed, but nobody's going to get paid. You want to make sure your contract at a bare minimum says that. Clear language of the contract is in effect. That's something standard. You want to address conflict resolution and jurisdiction provisions. Why? Because you might be entering into a contract with somebody in California. So you want to go and file a lawsuit in California? You probably don't. You want to do it here in Florida, in Miami or Broward. We can simply put it in the contract, the jurisdiction, it's here in the state of Florida, and that venue is proper in Miami-Dade County or Broward County, and that will save you a lot of headache. Even if you're negotiating with people in California, Peru, wherever they are, if they agree to jurisdiction and venue, now you're going to be in the driver's seat. Should you need to bring a lawsuit, you can do it right here, and we can assist you. So these are the basic things that I think every contract should have. Remember that even an invoice is a contract. So if you have an invoice, you want to make sure to include that. Another thing that I would include is attorney's fees and costs, because what good is it that you sue somebody because they failed to perform the contract and now you won, but now you spend over $30,000 in attorney's fees and costs, and that's not recoverable under your contract. So you want to make sure that you have a provision for attorney's fees and costs so that the winning party can get back their attorney's fees and costs. That's not automatic. You could only get attorney's fees and costs if your contract allows it, or if you're given that pursuant to a statute. For a breach of contract, you want to make sure that you put it in the contract, that the winning party will have the right to get their attorney's fees and costs. All right, so lastly, just want to say a couple of things that we do or that we can help you with here, besides the other things that we do, but we can help you negotiate employee contracts, prepare and file government reports, draft legal documents, review new business relationship with vendors and subcontractors, guide managers on regulatory and compliance matter, formulate employee handbooks, analyze legal issues with proposed products or services, help you with trademarks, deal with any type of governmental entity, help you with immigration and compliance, and of course, deal with your litigation and any type of real estate issue. All of that are things that we can help you. And here with business owners, what I see a lot is that they feel that they have to go to a different attorney for different things. In our office, we have attorneys that specialize within different focus, but if I'm helping a business owner, I'm going to be the one responsible and working with the attorneys in my firm, whether it's real estate, probate, immigration, whatever it might be, so that the client only has one person to talk to and feels more confident dealing with all of their business side of things, knowing that their legal side is, properly handled. Julisse, at this time, I want to know, do you have anything to say about contracts, or should we start taking questions?
No, I think we can start taking questions.
Okay, awesome. So in the chat or in the Q&A, if anybody has any questions, please go ahead and post them and we will answer them accordingly. Don't be shy. If not, you could always email us your questions. My email, let me see if I have it here. It's Romy, R-O-M-Y, @jflawfirm.com. And our phone number is 305-323-0234. I'm going to put it here in the chat. So if you don't want to ask your question here publicly, that's okay. You can still reach out to us. We are fully bilingual. We're open, even during this time, we're still fully operational. So if you guys have any questions that you don't want to ask here publicly, that's okay. Okay, so here we have a question. It says, how long does it take to evict a commercial tenant?
Do you want me to answer that?
Yes.
Okay. Well, it depends. It depends what you're suing them for. Are you suing them for non-performance of the lease, or are you suing them for non-payment? If you're suing them for non-payment, they have, after you serve them, they have 5 days to respond. Now, what happens? They can respond and say, well, I don't agree that I should be paying rent because my roof collapsed and my business was damaged, and I shouldn't be paying $5,000 a month of rent because I can't use half of my premises. So if that's the case, it's going to take more time because the judge is going to have to decide and look at those issues. If they simply don't answer, then, on a regular time that is not COVID times, I would say approximately 3 months to get somebody out, maybe less, but you got to account for the judge doesn't have time in their schedule. We haven't been able to serve them, whatever the case may be. Right now, it's kind of difficult to say times for anything related to the judiciary, because we don't know on a day-to-day basis what's going on with courts. But the courts are available through Zoom, and we try our best. So we're always going to do it as fast as we can, but it depends. The answer is it depends what you're suing them for. If you're suing them for other issues and non-payment of rent, then they have 20 days to answer, and then everything gets elongated. You have to wait until they answer. Maybe they ask for more time, and things like that. So it depends.
But if you're suing them for non-payment of rent, they only have 5 days to answer the complaint. And the only defense usually is, I did pay the rent. And if they didn't pay the rent, the only way they can defend is by making that payment into the court registry and then saying, okay, now I want to litigate why I don't think the landlord has the right to that money. So if you're in the landlord side, what you want is that everything in your lease becomes rent. If you increase the security deposit, it becomes rent. Everything, any other fee becomes rent. Why? Because now you can sue them for non-payment of rent and only have to give them 5 days to answer the complaint. And the only defense they're going to have is, I pay the rent. And in order for them to properly dispute it, they have to deposit that money in the court registry. If you are the tenant, the commercial tenant, you want to make sure that not everything is rent. And you want to make sure that you understand what your rent responsibilities are, so that you don't have only 5 days to answer the complaint. Now, if somebody wants to evict the tenant because they're doing bad things, they're violating the lease in any other way that it's not about not paying rent, then yes, it's going to take 20 days. They get to answer. They may claim some stuff. If they don't answer, then we default them after 20 days, and then we can proceed with the eviction process. If they answer, then the judge has to see whether their answer is valid or not. So yes, it depends, but non-payment of rent is probably the quickest way to do it. All right, I don't see any more questions. At this time, I want to thank everybody for attending. Oh, no, one more question. Oops. Oh, no, not a question. Just thanking us. Just want to thank everybody for attending. Julissa and I are always here to answer your